Okay, Assalamualaikum warahmatullahi wabarakatuh. Um, I see here that the recording is started. Maybe someone has started the recording. It's recorded, isn't it? Okay. Well, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. We will begin with the class of Public International Law. In the last class, we have talked about the preliminary areas of international law, mainly or primarily on the description of public international law. What international law is. So you have given me a lot of feedback in the last class, and you've mentioned to me that public international law is a body of rules, a body of law about something to do with international relations between states. And okay, and then we expanded the description. We say, well, it is a relation between states, between rulers, but as time goes by, international law has become wider. So it also includes um, um, uh, areas of protection of certain rights, okay? And the law evolved through custom and practice, and that would be also in the form of treaty makings and etc. So we've mentioned as well generally the areas of international law, which includes areas which concern states as a whole, for example, law of the sea, warfare, and etc. Okay, so in the last class as well, we've mentioned about the objective of the class, and I would like to relate the objective of the class to your course outline. Well, what we want to do is for you to know the basic principles, okay, the sources where to find the laws, and as much as possible, the issues of public international law as you see around you. We hope that you could relate to the fundamental principles that we come across in this class. And secondly is for you to be able to do research on your own to find where the law is and to apply the relevant principles in international law given situations. And eventually we want the students to appreciate the importance of public international law, especially for us living as a global citizen or a citizen in the 21st century. Right, we have also mentioned about the assessment methods. We know it's 50%, 50%. We will be doing some written assignment, presentation, and report. So hopefully I will be able to give you the details of these assignments, presentation, and reports in the next class. So for these first two classes, I want you to be accustomed to the understanding of the course that you are going to, and by next week, inshallah, you will be ready to go on for your tasks for the purpose of this class. I've also talked to you about the course syllabus, all right? We will be going through important, fragments or important concepts in international law, um, nature or development of international law. We did that, and then sources of international law today. Further on, we're going to look at the relationship between international law and municipal law. Municipal law means domestic law or national law. And then we will look at subjects of international law, state territory, state jurisdiction, immunities from jurisdiction, the law of treaties and the law of United Nations, the law of state responsibility, legal regulation of use of force, peaceful settlements of international disputes, and other aspects of public international law. So it will generally be a cramped course on the important principles, just for you to know if you are involved in international law activities such as moots or writings or readings. You will know that much of these concepts you have come across in this class. References. I know many of you have already got the book of Public International Law by Professor Abdul Ghaffur. Yes, you can read the book. It's a simple version for you to understand a lot of things. But I would always encourage you to read other books as well as articles. Okay, for each matter that we are talking about, there are actually a lot of writings about it in the form of articles. Okay, you will also read in the course of this subject international legal texts like the UN Charter, the various conventions, and as well as cases from the ICJ and other ad hoc arbitrations, international arbitrations. Okay, in the last class, these are some of the definitions that I collected. Well, as I mentioned to you, you will see you can also make your own commentary on these articles. So whether you agree or whether you think the definitions are comprising enough for the understanding of international law. So basically, you know, most of them talk about the body of principles, customs and rules derived from international agreements, treaties and customs. And what do these rules do? They effectively bind states, okay, and make the states be obliged by the agreements, and not only states, entities which are given international personality. So you see, if you have international personality right now, we know that international law has also been expanded to other entities given international personality. Okay. The evolution of the definition of international law, we have mentioned just now, the traditional assumptions, only states can be subjects of international law, but now it involves, for example, international organization. Okay, in the Vienna Convention, it mentions this. Okay, even NGOs can also be parties and also can attend ICJ cases to listen to as parties, as amicus curiae. Okay, ICRC is the International Red Cross. It is also mentioned in Geneva Convention, and private entities like private entities and individuals or non-state actors are also increasingly being talked about on their participation in international law. Okay. All right, and it also includes more legal rights and obligation, and also includes the relationship between sovereign and the subjects. Okay, for example, for international human rights obligations, if you notice the ECHR, the European Court of Human Rights, they would have there are many fundamental rights which states have obliged themselves to cover for individuals. So individuals can bring claims directly to against the state, okay, because of the infringements of certain provisions, right? And then also the inclusion of affairs of domestic community, again on human rights. So if states are impinging or infringing certain rights, then it can also be a matter of international concern. All right, this one is important for you to know, because in this class we are talking about public international law. So being public, at the same time, you would probably know that there is also another part of international law that is private. So public obviously means that it is primarily about states, okay, generally applicable to states. And the rules are derived from international law. I mean, not from the domestic form of the state. And the areas of law in public international law is basically matters which concern the general public, like international criminal law, maritime law, the law of war, human rights, and refugee law. But for private international law, okay, you can take, for example, disputes arising from individuals of different states. Okay, and here you would see the issues that will be talked about is which law to be applied. So in situations like that, there will be specific discussions about conflict of law. So this area is also known as the international conflict of law. Another example is with states which sign into agreements with another state on a bilateral capacity. So you would see that agreements would that disputes would only be related to the treaty which is entered into by these two states. Okay, and normally if there is any dispute, or in the treaties they would already say which law to be applied. Okay, or if in private individuals arrangements, they will also always put in contract which law to be applied. But if they do not put the law to be applicable, then you will have issues of conflict of law at the jurisdiction level. Okay, so as for private international law, you will see issues are mostly for business and individual relationships, and the development of law is through legislatures of states. So basically the states would if it's between two states, the states would okay, the inclusion of the local law would also be applicable. Okay, for example, if you do not specify which law, then you would end up to apply the law, for example, which has the closest nexus to the case. This one is for the court or the arbitrator to decide. So then eventually you will have your local law to be applied in your international dispute. That is how local law could be applied in situations like that. Okay.